Hello, everyone, and welcome to Uncivil Law, where we gain legal knowledge through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe and hit the notification bell to get alerts of our uploaded content. For today's story, we're dealing with a cop who was fired due to some statements he said, but it's a complex case with maybe some understanding to go around for both sides. This is the case of Randy Henry versus a whole bunch of individual people who he thinks wronged him. In this case, Mr. Henry said some things, and the police disciplined him and fired him for these things. So can the government do this? Is this good? Is this bad? How do we feel about this case? Well, let's get into the complexities and try to understand. Let's get started with this. This suit arises out of a May 2014 drowning of 20-year-old Brandon Ellingson while he was in police custody on the Lake of the Ozarks. So the police have this guy in their custody on a lake, and he is drowned. So that might be a problem, obviously. The case resulted in a series of civil and criminal cases and internal investigations. So a very big problem indeed. Whole bunch of investigations relating to this. While these investigations were occurring, Sergeant Randy Henry, our protagonist, spoke out several times against or about the police officer's role in this drowning. In October of 2014, Henry testified twice before a special committee of the Missouri legislature, who's also looking into this issue, to look into a merger of Missouri Highway Patrol with Missouri Water Patrol, the combined entity that's now known as this thing. So they're looking at combining these groups, and he wants to testify. First, he testified in his official capacity, and then he testified in plain clothes as a private citizen. In 2015, he also gave a deposition for a civil lawsuit concerning the Ellingson case. These instances made what were referred to as testimonial speech. So, Mr. Henry here has some thoughts regarding what the police did or did not do with respect to this incident in which a person drowned while they were in their custody. And he's offered some formalized testimony on this before the state legislature, and also in some sort of deposition regarding a civil suit. So that's one thing, and then there were some other things. So let's read some more. Henry also spoke numerous times to members of the press and members of the Ellingson family about what he claimed was an internal cover-up of the drowning. Henry also raised the possibility of internal corruption during the investigation of the drowning by insinuating the special prosecutor in the case may have been involved in a quid pro quo with the police to exonerate her son in a sexual assault allegation. So he thinks that there's a special prosecutor appointed, and he thinks that the special prosecutor is in a conspiracy with the police in order to help protect her son. The special prosecutor interviewed Henry, the officer, our protagonist, as part of this investigation, and during this interview, he admitted to spreading information about her son. And after interviewing, she recused herself from the investigation, which makes perfectly reasonable sense, right? She's a special prosecutor being appointed to look into this special issue because we're concerned maybe with police corruption. So we're going to appoint someone specially for this to look at it from the outside. And now we have this person in here who's saying, well, you're corrupt too, because you're trying to bury this. Even though you're the special prosecutor, you also are corrupt. And so she has to recuse herself as a result of that. So that's potentially concerning. All right. In March of 2015, the special prosecutor filed a complaint against Henry, which was investigated by the appellee. The appellee determined Henry had violated general orders, which led to two prosecutors asserting they would no longer bring charges brought by Henry due to concerns about his trustworthiness and integrity. All right, so there's a whole bunch of possibilities here, and I'm reasonably open-minded about what these possibilities are. So I am not necessarily at this point inclined to believe anyone over anyone else. So it could be that Henry over here has some special information and he is truly seeing the corruption and he's blowing all the whistles. But it feels just a touch conspiracy theory. And it feels a little bit like something's off. And two other prosecutors have said that they don't want to bring any charges from this guy as a police officer because they don't trust him. They don't feel like he's being honest or that he's trustworthy. So there's a couple possibilities. So, there's a possibility that, everyone's corrupt or he's corrupt. Someone's corrupt in this situation, at least, right? So all these other people are corrupt, and the two other prosecutors and the special prosecutor are corrupt, and the police department as a whole is corrupt, or this guy. At this point, I'm not particularly inclined to believe this guy. I'm not saying that he's wrong. I'm just saying that I'm skeptical, because it seems like a lot. But let's read some more. Henry ultimately filed a complaint against 11 of the defendants, this would be his fellow officers, for retaliation for protected speech, violation of his civil rights, and for a failure to supervise. So he wants to say that you have done a whole bunch of bads against me, and I want to sue all you people for the bads. All right, let's figure out what the standards that apply. Henry alleges unlawful retaliation by the police department for protected speech in violation of the First Amendment. In response, the appellees claim they're entitled to summary judgment based on qualified immunity. Our first inquiry is whether Henry has established a First Amendment violation. To establish prima facie case of unlawful retaliation for protected speech, Henry must prove that he engaged in activity that's protected by the First Amendment. Second, Henry must prove that the police department took adverse action against him. And third, he must prove that the action was based on the thing that he did, or his speech. So he has to prove that he has protected speech. He has to prove they did bad things against him. And he has to prove they did the bad things because of the speech. All right, so let's look at that and see what we have. First question, is it constitutionally protected speech? Now, I'm sure you guys know from previous coverages of our channel that this gets complicated because he is a state official. And we have to determine whether it's his speech or the government's speech. Because if the government has the First Amendment right to protect its speech just like an individual. So we have to determine the degree to which he is speaking as an individual versus the degree to which he's speaking as an official, and the degree to which when he's speaking officially, he might be in violation of department guidelines or otherwise. So that's the first thing we have to determine. Is it his speech or someone else's speech? So Henry alleges, and the police officers involved do not contest, that all the testimonial speech is protected. So the times that he talked to the legislature, protected. The time he gave that deposition, protected. Great. Henry, however, also argues his remaining activity, such as speaking to news reporters, and personally for me, which is a little bit concerning, directly talking to the Ellingston family, which in the middle of an ongoing police investigation for this one cop to go outside the normal mechanisms of how detectives do their work and talk to them separately, it raises questions in my mind. And on social media, even more concerning, that's non-testimonial speech. Well, that much is true. It's not under testimony. And in our view, however, he fails to show this remaining speech is constitutionally protected. Under Eighth Circuit precedent, we must proceed through a multi-step analysis to determine if this non-testimonial speech is entitled to First Amendment protection, which, of course, starts with whether he spoke as a citizen as a matter of public concern. So is he speaking privately as a citizen, or is he speaking as a police officer and therefore violating the government's speech? It is undisputed that Henry spoke as a private citizen, not an employee, while making his non-testimonial statements. So we got that covered. So Henry was speaking as a private citizen. Okay, great. Therefore, to proceed, we must determine if it was a matter of public concern. Because if it's a matter of private concern, then not so much. When the speech involves a matter of political, social, of concern to the community as a whole. In the case of Henry's speech, taken in the life most favorable to him, it was of public concern. The statements of social media, to the Ellingston family, and to the newspaper all concern the integrity of the system. Henry spoke critically of internal investigations suggesting a corruption. Such statements are relevant to the integrity of the Highway Patrol and prosecutorial divisions, both important functions. We therefore conclude his non-testimonial matters are also matters of public concern. So, step one of our analysis we have completed in Henry's favor. All the speech we have concluded is protected First Amendment speech. This is matters of public concern. He is speaking privately, not in his professional capacity. So we got that going for us. Unlike some of our other cases where this has been more conflicted, but we don't have that problem. We don't have him like speaking in a uniform or something like that. It was always in his private capacity, or at least the other side's wanted to say it was. All right, so what's next up on our analysis of the relevant factors. Next, a public employer must, with specificity, demonstrate the speech at issue created a workplace disharmony, impeded plant performance, or impaired working relationships. It is not necessary to show an actual disruption. An employer need not show that allowed events to unfold to the extent it's a disruption of the office and disruption of working relationships is manifest before taking action. Okay. All right, so in this factor, we're considering the police department as an employer and their interest in an employer and their interest in employees. Now, any private organization would be able to fire an employee for pretty much any reason they want, right? Not having the right heart, not being able to work well with their colleagues would be a perfectly valid reason. And the government also has an interest in its employees being able to work well with each other. So the employer, in this case, the police officer, can consider the degree to which he has a good working relationship or not with his other police officers and other people, because he needs to be able to work well with them. And if he can't, then maybe that's a problem for them as employer, regardless of whether his speech is protected, because they're not, strictly speaking, in that situation acting as the government. They're acting as an employer. And so you have to kind of maintain the distinction between those two, which can be difficult, but that's what courts are for, right? So to the extent that they're acting as an employer, they're not really acting as the government. They're acting as an employer, even though they're a public agency, which kind of makes sense. And that they can have the same sort of position as a normal employer in that respect. Here, the police force has shown sufficient evidence of disruption to efficiency. The undisputed facts demonstrate that 2 prosecutors have refused to take cases, citing lack of trust and integrity with Henry. If prosecutors will no longer press charges from a particular officer, this would impede the ability of the agency to function. Further investigation by the officer who looked into this concluded that Henry violated 3 of the police officer's general orders, 2 of which relating to disruption and inefficiency. And the fact that we've got the prosecutor's office, who's external to the police, at least in some respect, also saying they don't want to do it, is somewhat suggestive that there's something going on here that might be real. Because the police force demonstrated a deterioration in trust within Henry's troop and that Henry engaged in unprofessional behavior that violated the orders, the police department has demonstrated that his speech did in fact create a disharmony and impair working relationships that might allow the government to act. Okay, so now we have 2 potentially competing interests. We have Henry's interest in his speech, First Amendment protection, and we have the government's ability to have a good enforcement, a good workforce, one that works well to each other and one that's not unduly disruptive. So how do we balance these twin interests? How do we balance the interests of the individual being allowed to speak with the government's interests as an employer, not so much necessarily as the government, but as an employer, and how do we regulate those 2 things? So because of the governmental context, we had to come up with a complex balancing mechanism, which came in the case of called pinkering. So now we're going to apply that test and figure out which way that slices to figure out which one of these 2 should win in this particular situation. So let's do that. Under the Supreme Court's precedents in Pickering, we must take account of a number of interrelated factors in balancing competing interests of government employer and citizen employee. 1, the need for harmony in the workplace. 2, whether the government's responsibility requires a close working relationship to exist when the speech in question has caused the relationship to deteriorate. The time, place, and manner of the speech. The context in which the dispute arose. The degree of public interest in the speech, and whether the speech impeded the ability to perform. So not just hypothetically, but in reality. As we've repeatedly recognized, more so than a typical employer, the Minnesota Highway Patrol, or for that matter, any police office, has a significant government interest in regulating speech activities of its officers in order to promote efficiency, loyalty, and obedience, maintain morale, and instill public confidence. So because the police and its function, it is important that when the police officers are speaking, they do so in a way that helps to maintain the overall cohesion of the unit as a whole, whatever else they're doing. So there is an interest there that is legitimate and has to be factored in. As to the balancing elements, first, the manner and place of the speech weighs heavily in the government's favor. Henry spoke directly to the Ellingston family during the internal investigation, which seems like just a bad plan from all kinds of things. In terms of polluting the investigation, it's going outside protocol. It just does not seem like a good idea. And he spread unsubstantiated information by repeatedly speaking to a news reporter and on social media. Secondly, unlike a legitimate whistleblower, Henry did not substantiate any of his allegations, especially those involving the prosecutor and son. So he said, well, the prosecutor did this to benefit the son. And he has no evidence of that of any kind before he just spreads this on the internet. Seems a little haphazard. Third, Henry's role as a police officer is closely tied to other officers and prosecutors who bring charges connected to arrests. It's essential for Henry to work closely with these people. The evidence reveals that accusations Henry shared online and to the family deteriorated relationships with prosecutors by the two who refused to take cases. The culminations of these factors weighs in favor of the police's interest in efficiency and indicate the speech activity was more likely than not impeding his ability to perform. As such, we conclude that non-testimonial speech is unprotected, or at least in the balancing factor that it should go for the government side. Finally, we must determine whether Henry's protected speech activity, the testimonial speech, was a substantial or motivating factor in the police department's decision to take the aforementioned adverse actions. While causation is generally a jury question, this court must decide if sufficient evidence exists to create a factual question for a jury. To make this determination, we must undertake an additional three-part test. First, the public employee must show they suffered a harm, that the burden shifts to the employer to show a legitimate reason, and then it shows back to the employee to show that it was a mere pretext. For Henry to prevail, then, he must establish a factual question exists as to whether the police department's reasons were mere pretext, a difficult burden to prove because of pretext and discrimination is viewed in light of the employer's justification. So yeah, proving it's a mere pretext is difficult because if the reasons are sufficient, then how do you prove it's not those reasons? Now, it can happen. It would be nice if you had a smoking gun, but short of that, yeah. Such a pretext may be shown by offering an employer's explanation lacked basis in fact, evidence the employer received favorable reviews, evidence that the proffered reasons changed over time, so it was inconsistent, or evidence the employer treated other employees better. So, yeah, you can show this through a lot of different ways, but not really here. Here, the police's disciplinary actions were based in fact. They specifically related to Henry posting to social media, speaking to a news reporter, and conversing with the Ellington family. These occurrences are established and undisputed, and although Henry did receive generally positive reviews in his work, this review was given before the full extent of conduct became known. And even in this favorable review, it noted there always seemed to be someone Henry is upset with or is upset with him. There's no evidence to support an inference that the police department's reasons have changed over time. In summary, the people sued are entitled to qualified immunity with regard to the count because Henry has failed as a matter of law to show a constitutional violation. Much of the speech is unprotected because it fails the balancing test. Now, I do take a little bit of chide here with him saying unprotected. I would not write that. I think that's wrong. I wouldn't go. I think to say it's unprotected is not correct. I would instead say that the balancing factor favors the police as an employer. But I think it's wrong to say the speech is underlyingly not protected. So I think that's a mistaken language from me. Because it fails the overall harmony of the public interest. The remaining testimonial speech is not a substantial factor in the adverse employment, which that does seem to be true. There doesn't seem to be any evidence that we're punishing him for his protected speech. There seems to be more than enough of unprotected is again the wrong word, of speech that is sufficiently detrimental to the police department as a whole as to constitute a place problem for the government as an employer is probably better. Yeah, I don't know if unprotected is the correct word. I don't know if they're using that because this is a slight legal blind spot, right? Are they using that word because that's like the correct word here, or is that just a misspeak? Because it just doesn't. It's not quite right. It's not quite right to say unprotected. I think. Because if it were truly unprotected, that we're like that's another possibility, right? Because we could have that reality. It could be unprotected speech because it wouldn't be his speech, so it would be unprotected, right? So we could have that possibility. We're not in that possibility. It was his speech. It's a matter of public concern, blah, blah, blah. So it's First Amendment protected. So when the court then turns around and says it's unprotected, I think they're misleading or they're making a mistake there. It's not helpful in the understanding of the case. Thus, that brings us to the end of the case of Randy Henry versus a whole bunch of people. In this case, Mr. Henry was a police officer who has some questions and concerns with a police investigation, which might be perfectly fine. However, the methods that he went to express that may be less so, including his spreading of rumors that don't seem to be backed by really anything. And other prosecutors have lost confidence in him and said that we don't find him reliable, so he's been fired. And Henry says, well, you fired me because of protected reasons. And the court's like, no, not really. You have a First Amendment right to speak, but they also have a right to, as employer. And you seem to be going well outside of, the bounds here by just going on social media and just talking off the cuff here. So this doesn't seem to be really great. You're undermining confidence where maybe it doesn't belong. So you can decide for yourself who is more in the wrong here. Is Henry, who's more in the wrong? Is Henry right that there's a deep sea of corruption, which, that's definitely possible. We've seen crazier things in our coverages. So everyone's corrupt is definitely a possibility. Or, Henry's a little bit off. Might also be a distinct possibility worth considering. So which is more likely, I'll leave up to you, but at least for a moment, that's the end of the coverage of our case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.